So sometimes it happens that grandma passes away and made zero plans regarding her estate. Does that mean that all hope is lost? Of course not. Today we're talking all about an affidavit of heirship and how you can use it to recover title to property even when there is no will or when it's been way too long to probate that will. Let's get started. So sometimes it happens that family members inherit property in an informal way. Everybody knows that grandma intended for little Joey to inherit the property, and sure enough, he's there, he's still living in the house, maybe he's leasing the property to another party, but eventually he thinks, you know what, I think I would like to sell this property, but Joey can't sell it because he doesn't hold actual title. Title is still in grandma's name. Is all hope lost? Of course not. And so today I'm going to explain one procedure that could be helpful even without a will, even without probate, where Joey can take title. And that's called using an affidavit of heirship. Now, in different states, this procedure and the name of the document could be different. That's okay. And so I'm going to talk from a Texas perspective on how these things get done and what maybe you can do in order to secure title long after your loved one has passed away. Now, the procedure for this in the state of Texas is found in the Estates Code, and section 203.001 and .002 give us what we need in order to proceed with an affidavit of heirship. In fact, they set it out. They give you a template to follow with all the questions you'll need to cover in your affidavit and answer by your affiant who's willing to swear to these facts in order to assist you with the transfer of this property. So what exactly do you need from an affidavit of heirship in order for it to function properly? Well, we always suggest two disinterested witnesses. And a disinterested witness is not someone who doesn't care about the situation. Instead, it's someone who will not benefit from the situation. So usually a family friend, occasionally it's a family member, as long as that family member does not directly or indirectly benefit from the transfer, it should be okay. Now, naturally, we would never suggest that you continue to delay before you sign and file your affidavit of heirship. The problem with delay is that eventually the people who know the facts that are relevant to this kind of document will also die. And so you want to get this as soon as possible so that you can record it and preserve the distribution of title without the need to file a complicated lawsuit. Remember, this is appropriate when either the individual left no will, or if a will was left, that so many years have passed that it is no longer eligible for a probate. When this occurs, sometimes the chain of heirship is so vast that it's nearly impossible to find someone who is knowledgeable of the prior individuals, or it's so difficult to just track down who all of the possible heirs are in order to make this document effective. But the sooner, always the better. So after you have your two disinterested witnesses, you have to identify who the heirs are. And so we're going to talk about intestate distribution and the way that it works in Texas. So whenever there's no will or no ability to probate that will, how does property transfer in the state of Texas? Now, this can get complicated depending on different scenarios, but I'm going to reveal to you just the simplest, the most basic form that is available. And so basically, if you have an individual who is married, so it's husband and wife, and the husband passes away, intestate distribution says from husband, everything flows to the wife. Easy peasy, that's the way it goes. And so if you are dealing with a surviving spouse to recover property from a deceased spouse, the affidavit of heirship should identify that this individual had a spouse and that the spouse was her sole heir. In this very simple scenario, that's how the distribution would go. Now, sometimes the spouse has predeceased, and so you have a parent with children. And so there's no distribution across to a spouse. Instead, the distribution goes down from a parent to the children of that parent. And again, very easy to identify. And so an affiant would swear to the facts knowing the deceased parent and that they had these heirs, these children. But not every person is married and not every person has children. And so if you have an individual who has neither a spouse nor children to distribute their property to, well, the distribution goes up from the individual to their parents. And so if mom and dad are still living, or either one are still alive, they would be the heirs at law of this individual who passed away without a spouse and without children. The distribution goes back up the family tree to mom and dad. But if mom and dad have predeceased the individual who has no spouse and no children, then along with going up, it cascades back down to the siblings of the individual. And so any living siblings of the individual are the next heirs at law. And this can keep going up and cascading down over and over and over until an heir is found. If mom and dad are dead and there were no siblings, this is an only child situation, then the distribution goes up to grandma and grandpa. And if they are dead, then it goes down to their children and cascades down to theirs and over and over and over until heirs are located. Which is why I mentioned the longer you wait, the more complicated this distribution gets, so that it's much better to do it sooner rather than later, because, again, it can get messy. Now, what's in the affidavit? Well, first, you have to identify the person who is swearing to the facts. And they will identify themselves in the affidavit as a person with personal knowledge of the individual. So the witness will state that they knew the deceased and when they met the deceased and for how long they knew them personally. It will go on to describe the marital status and that that individual was aware of the marital status of the deceased and aware of the deceased's children, both those born of the individual as well as those adopted by that individual. The affidavit goes on to state that this witness knew that the deceased had no will and or no administration of their estate. It also goes on to swear that they understand that no debts were owed, or if there were remaining debts, what those debts were, and no taxes were owed, and if so, what those taxes were. Finally, the affidavit identifies the property in question and the heirs who are the beneficiaries of that property. The affidavit is signed by the witness and then notarized by an individual authorized to do so, who is present at the signing of the heirship affidavit. And then a second heirship affidavit. In an ideal situation, you've got at least 2 disinterested witnesses who swear to these facts and sign on the line. That document, or those documents together, which make up the heirship affidavit, are then recorded with the county clerk's office. In the state of Texas, deeds and liens and heirship affidavits are all filed in the county clerk's office, in the property office where these things are preserved and made available to the public. And so once the affidavit of heirship is on file, the whole world is on notice that the property which once belonged to your deceased family member has now distributed to the heirs at law. When it's a single individual, no problem. When it's multiple individuals, it can get complicated, but whether it's one or many, that's the way you would distribute title once an individual has passed away, either without a will, or if they did have a will, years after or sometime after the ability to probate that will has come to an end. That property doesn't necessarily stay stuck in limbo. It can transfer so long as you can identify 2 disinterested witnesses who can swear to these facts, and then you sign this affidavit and record it with the property clerk's office. After that point, you can then, as an owner, do all the things that an owner does, including altering the property, leasing the property out and selling the property in the future. Let me know if this information has been helpful to you. If so, give us a like, leave us a comment or a question if you have that. I'll personally respond. And if you haven't subscribed yet, please consider subscribing. Certainly, if this was helpful to you and you find yourself asking more questions, YouTube seems to think that this video right here is the next best thing that you should watch. But feel free to check out all the rest of our content on this channel. We welcome you to do that. And until next time, happy leasing.